So, Roland, thank you so much for asking me to sit down. Um, I have a significant background in the subject matter that we'll discuss. Most of my career was at Deloitte and Duff and Phelps, and so you can imagine dealing with large-scale accounting malpractice and bankruptcy while at Deloitte. Dealing with heavy creditors, preference issues being kind of a different story to smaller clients. And then as I went in-house at Citigroup doing internal investigations on their wealth side, and then going to Duff and Phelps, I started focusing more on asset management. And so while that might deal with private equity and hedge funds, the underlying assets are often corporate corporate investments and companies that end up contemplating insolvency and having to deal with preference issues. And now at Stout, it's obviously interesting times in the insolvency space, and certainly interesting times when it comes to this law being put into practice.
Yeah, so to talk about the law specifically, what do you think? What is the burden on the plaintiff? What kind of due diligence do they need to do?
I think it's clear that they should do diligence more than just pulling the accounts payable records, right? Maybe in the past it would be running down accounts payable, looking 90 days or a year for insiders or something, and just hitting the play button on some of these litigation actions. It's more than that. I think you really do need to look at what potential defenses might be, and just look at the interaction of the payment process and of these vendors. What's the history like? What's it been like? What is the communication? Have the payment terms changed? Like, you need to be able to answer those questions at a minimum, just based on this law going into effect.
So, do you think they should do a statistical analysis of ordinary course comparing a base period and a preference period?
Yeah, I think if it's not too much trouble, which personally, I mean, we do those. It's not doesn't take too much time to be able to do that. And I guess this may be a constant theme in some of the discussion. The facts and circumstances of every bankruptcy matter are different, but if you're talking about thousands of vendors or hundreds of vendors, it might be something different. But to look at what's material and just take a deeper dive into the ordinary course, the industry, yeah, it's I don't think it's too much of a burden.
What kind of statistical analysis? Let's say it's a large case. Would you do a standard deviation analysis in a preference case?
It would depend. It really would depend.
Could you render an opinion on whether there's an industry standard defense, and is that something that should be looked? I'll just ask you: is that something you think that should be looked at? An industry standard defense?
I do think it's something that can be looked at if the circumstances warrant it. I oftentimes, depending on the industry, I'm the appropriate person to opine on it. But what I will do oftentimes is rely on colleagues in other jurisdictions or in other industries that have been doing the accounting and the valuation for 25, 30 years, and kind of have a sense of the way the industry works, and what is typical and what's atypical. Um, and so yeah, I think it's valuable to speak to somebody that has been functioning in that industry for quite a while, and has the ability to opine on it. At some point, I don't know how much you want to make this about the pandemic, or not make it timeless so it's not about the pandemic. But that's one of the most interesting topics to me, is that what is ordinary course when there's nothing ordinary about the past 12 months, and then we anticipate being engaged quite a bit to say, okay, yes, we could tell you that this is ordinary course, but the past 12 months payment terms are not ordinary. There's government money that's coming in that changes things. There's the way that people are handling their receivables and managing their receivables is totally different. The way that people are managing their payables is totally different. Like, you tell me you're going to look at retail and say that this was ordinary course, like, forget it.
It seems to me like maybe there'll be more of an industry standard defense because the base period. What's going to happen with the pandemic is the preference period is not going to compare well with the base period because of the pandemic. However, the entire industry is paying differently. So, do you think that might be a factor?
I definitely do. I think one thing we have learned from the pandemic is that certain industries have been impacted holistically. That it's clear, retail has shifted during this period, and maybe even arguably has shifted, for the next 10 years, based on behaviors that are developed here, as one example, or hospitality. These industries can kind of, we anticipate opining in an expert capacity based on how the industry has been impacted, and therefore how it's affected the finance function of these companies in the industry. It is jurisdictional dependent, but I think if there's no harm in looking at both, and if we're talking about this, this 2000, this expansion of the 2005 law, like, um, why not? You certainly, if you're working with a debtor, if we're talking about the plaintiff and you're working with a debtor, you have a clear understanding of that industry because you've been engaged to assist. And so that shouldn't be too difficult of an assignment. And if you're doing your due diligence as the law is requesting you to do, then I think it would make sense to look at the industry of the creditor. But yes, you're right. It is dependent on the jurisdiction.
So we know the plaintiff now has a due diligence burden. How does that benefit the defendant in preference case?
In the first instance, I think it benefits the defendant because there is a better chance that they're getting an actual case, an actual, a case based on some fact, not just that their name or their company was on a list or was on an accounts payable register. So, they can, there should be some feeling of there's a greater responsibility, and therefore they the chances of them not having to spend money for without reason is there. That's what I'd like to think. And I mean, I think it's putting this law out there. It's worthwhile now for the defendant to go at it. And we haven't seen much case law, but of the few cases, the plaintiff will have to answer the question, and the defendant, it gives the defendant the opportunity to ask it, in reference to this law.
And what are the teeth in this law? In other words, let's say a defendant decides the plaintiff hasn't done his homework and hasn't looked at anything. What can a defendant do?
That's, I think, yet to be seen based on case law, but by raising it and having the courts see that the trustee has kind of just gone through the motions and not given a thought about this, it looks bad, and it would put the plaintiff in the bad graces of the court, and just shed bad light. And it's not, it's always so hectic and so chaotic when you're filing a Chapter 11, and the debtor has so much to do, but it's worthwhile taking pause and just going that extra step. Something that we haven't talked about, but I think is worthwhile, is documentation. What documents should be requested in discovery, and what should be looked at? It's more than just the accounts payable register, as I've said. You want to look at the communications. You want to look at the payment terms and the contracts that are along with these vendors, and how making a comparison of what's actually been in practice versus what was agreed to initially.
Yeah, but the defendant is under no requirement to engage in that sort of informal discovery. So it could be a situation where the defense says, "No, we're not going to give you those documents. We don't have to," and then the plaintiff is not going to be able to, or I'll have an excuse anyway for not doing due diligence.
Right, they'll have that excuse, but they do have their own documents, so they have one side of the contract that they could look at, and they have payment history, and potentially have correspondence when things went out of typical payment terms, or when there were occurrences that affected the exchanges.
But so the quality of the record keeping by the debtor is going to be very important, because a lot of times debtors' records are terrible. So this is going to be an issue for plaintiff counsel.
Yeah, agreed on that front, but that is something that can be explained to the court as well. And again, like, as this question originally started with, like, how does this benefit the defendant? In some cases, it allows them to ask these questions, whereas before, it would kind of come out down the road after much hassle.
So it gives the defendant a little bit of leverage, more than it had.
Agreed. Yeah.